the delegation from the obligation not to close the transaction prior to the obtaining of clearance. So I'm going to discuss the very firm defense in this particular regard. So, as I said yesterday, the notifying party often requires from the competition council in order to speed up the clearance to benefit from that derogation. But most of the time they did it without giving any reasonable or legal basis. That's why before the COVID-19 crisis, we never gave such derogation. As I said, also it's an exception that has to be submitted to a rigorous condition, and we have to be careful while using it, because the common situation would be that a notified merger should be implemented before, should not be implemented before the CC or the Competition Council gives its authorization. But as you know, exceptional circumstances call for exceptional measures. It's during the COVID-19 and taking into consideration the fact that there is an urgency linked to some companies' financial difficulties. We gave for the first time in our decisional practice this kind of derogation. So if we refer to the legal framework, provision 14 of the Moroccan competition law impose two conditions to benefit from this derogation. The first condition is that the parties have to motivate, to give a motivation about a special need for implementing the merger immediately before the clearance. Of course, the burden of proof in that situation is on the parties. I mean, they have to bring us all the objective arguments, but also data about the special needs they have and motivated. And basically, this derogation can be granted and motivated in specific circumstances, like the urgency of presenting a takeover binding offer to acquire a company in a bankruptcy process, or if there is a risk of an imminent elimination of a company, or to allow the acquiring also company to pump liquidity or to bring warranties in order to ensure the functioning of the targeted company. The second condition that is required by our law is the implementation. Is that this implementation should be done without prejudice of the final decision to be taken after the examination on the merits of the merger as regard competition assessment, of course. Therefore, this derogation is designed to respond to an emergency situation that implies the necessity to act in a quick way and promptly way. So to come back to the Moroccan experience, we have received two requests to benefit from that derogation. The first case was about a merger involving two companies, or two groups of companies that are active in the parts car industry worldwide, and the merger had an effect on the Moroccan market. So they notified this merger to get a clearance from the Moroccan Competition Authority. And we find out that this merger implies, of course, or involve horizontal effects on the Moroccan markets. But of course, the companies, in order to make the process more faster, they submit a request for that derogation, and they provide, of course, some argument to that. So according to the financial statements, balance sheets, and all the financial documents that were communicated by the company, the financial situation of the targeted company was so critical because it suffered from a negative own funds. The debt was extremely high, and also they have suffered from finances losses due to many factors, but also to these factors were exacerbated by the crisis, by the COVID-19 crisis. So just for the recall, the companies that were involved especially the targeted one. They had initiated a collective legal procedure before a German court, which appointed a judicial administrator. The last initiated the procedure for the sale of the assets and shares of the targeted group, and consequently, the acquiring party, the notifying party in that for that merger, they presented a partial takeover offer concerning parts of the targeted company. In fact, and according to the elements provided by the party, the requested derogation aims to respond to many concerns of the customers' targeted company and suppliers and employees relating to continuity and its activity, while the Competition Council take its final decision after an examination on the merits. So as investigation services, we have asked for the company to give us certified documents from the administrators attesting that the notifying party was taken as a potential buyer of the target assets, and also the decision of the court announcing the opening of the collective procedure. I mean, in order to have a legal background for giving that derogation. So according to these elements, the first condition that was required by the Moroccan law was fulfilled. Now the second condition, we have to check up or to check if the delegation that is going to be given by or granted by the Moroccan Competition Council is not likely to be without prejudice of the final decision that is going to be making after competition assessment. So we have imposed to check this condition many remedies on the parties to ensure that the derogation will be strictly limited to the request aim of saving the company by pumping liquidity in a short run, and not to go beyond, but also to be sure that this derogation is given without prejudice, as I said, of the final decision of the Competition Council. So as I said, we submit this derogation to many conditions. The three conditions, if we have to summarize them. First, the derogation must allow only a limited exercise of the voting rights related to the share in a way of preventing the parties from modifying the structure of the targeted firm until the final decision of the Competition Council will be taken. Second condition, we prohibited the acquirer from integrating or ceding the assets of the target firm in a way likely to hinder the adoption of any corrective measures in the final decision, because we have to be sure that when the Competition Council will assess the competition on the basis of an examination on the merits, and if the merger is likely to impede competition in the markets, it will be too late if there is a lot of changes in the structure of the targeted firm. So we have to, in one hand, allow the targeted company to survive, but also without prejudice of the final decision of the competition authority. And the third condition is that the acquirer was expressly prevented from selling assets belonging to the targeted company, or to conclude any agreement with that which could prevent or make difficult the possible sale to a third party of the targeted firm assets, especially if the Competition Council final decision would be to ban this concentration or submit it to a structural or behavioral remedy. So that was for the first case. The second case, it was also a request that was presented to benefit from that provision, but we did best. We managed to close the merger examination in a short deadlines, so we cannot every time give a derogation to according to the provision set out by the law. So two requests, but only one derogation decision that was taken. The second case was just a final decision where because all the conditions for derogation were not fulfilled. So that's what I wanted to share with you today, and thank you very much for listening.
Thank you very much, Mr. Bouayed, for the informative presentation. So now I'll be briefly presenting the General Authority for Competition, Saudi Arabia's contribution with regards to the failing firm defense. So when asked what must be satisfied during the substantive assessment of this defense for it to be admissible, the GAC responded with clear and convincing evidence that a counterfactual other than the status quo, including a counterfactual involving a failing or failed firm, is more likely than the current status quo. With regards to the relevant procedures for the appraisal of the defense, the parties or the General Authority for Competition raise an alternative counterfactual, including a counterfactual involving a failing or failed firm, and they assess the evidence on a case-by-case basis to determine if there is sufficient evidence to support said counterfactual being more likely. Now, the defense is not available under primary legislation, but rather available by protocol and by forthcoming guidelines. The burden of proof would normally lie on the parties raising the defense. With regards to the rationale behind their treatment of failing firms, the appropriate test for merger review is if the merger would likely substantially lessen competition relative to the likely situation without the merger. If the situation without the merger involves a failing firm, then that is the appropriate point of comparison to determine the net effects of the merger. They assess the evidentiary elements on a case-by-case basis, and in that case, they would tailor their substantive assessment in that regard as well. When asked whether insolvency proceedings or imminent insolvency proceedings are usually considered sufficient, the response was that they may be, but it depends on the case, the circumstances of the case. And there's no fixed procedure in determining whether there is a less anti-competitive purchaser for the failing firm. If the entire industry is declining rather than one failing firm, then that situation would be considered the appropriate counterfactual according to the GAC. Currently, they have not handled any failing firm claims. None were invoked or handled. And yeah, so that summarizes the GAC's contribution with regards to failing firm defense. I think we can move to our Q&A session now, where we open the floor to our participants. Do any of the experts have any questions for Mr. Bouayed before we continue? Okay, perfect. So we're now opening the floor for questions from our participants.
Of course, questions or contributions or comments.
All right, so maybe I'll begin with a question.
Sorry, I have a question, if you don't mind, to the experts.
Of course, yes, please go.
Yeah, I want just to know, because I didn't start the meeting from the beginning. I wanted to know what are in the EU jurisdiction the standard of proof used by the European Commission or by your jurisdictions to assess the failing firm defense. If you could just give me a sum up about those criteria.
Hi, it is balance of probabilities, but the burden of proof is on the merging parties. There is a wrinkle in the UK depending on phase 1 or phase 2, but I think, painting with a very broad brush, as with any other assessment, it is balance of probabilities. Being a defense, though, the burden is on the merging parties. Hope this answers the question.
Yeah. And just another little question, if the moderator doesn't mind, about the economic models that were developed by the experts. I mean, are they used empirically, or would just rely on the notifying parties' documents and contributions? I mean, to what extent we use econometric models in such situation?
Econometric models are used in such situations. Parties, as Alex said, have the burden of proof on this, but I have when I was at the authorities, I have used econometric models to assess probability of failing firm. Whether they're heavily used or not, it's difficult to tell from the outside now. And Alex may have seen such a model. I don't know, Alex, you've seen models like this used in your cases before DigiComp or UK or other authorities. But when I was at the different authorities, we have used such models in the past.
Thank you very much.
I have a question.
Yes, please go ahead.
In your opinion, what constitutes sufficient evidence that a firm undertook to find a less anti-competitive alternative in good faith? Thank you.
So this is one of our colleagues at the Egyptian Competition Authority who just asked what constitutes sufficient evidence that a firm undertook to find a less anti-competitive purchaser in good faith. How do we assess a good faith attempt? What are the evidentiary elements?
So in my experience, obviously, you know, there's no silver bullet here, right? But in my experience, what they would look is essentially the efforts that they've tried to make in order to sell the company and who has shown interest. As you can imagine, when a company is failing, sometimes a white knight comes out of nowhere and you don't have time to do a proper kind of, open bidding. If there is an open bid in terms of who is, if it's known in the market, then it's relatively easy to see whether there have been more, I think you've expressed it as pro-competitive purchases, right? Otherwise, you just try to understand contemporaneously at that time what has happened. So in my experience, it was evidence presented before the board in terms of the sales process, who has shown interest, investment bankers' reports, essentially saying to the seller who would be a potential purchaser, and ultimately interviews with the seller's business people and counsel, trying to understand how the process developed and who essentially showed an interest. What was very difficult in one of the cases that I was involved was that after the event, some of the competitors presented themselves to the authority and said, we could have bought this asset, although evidence showed pretty clearly that at that time they were not really interested, or they didn't put money on the table. So again, I don't have a very solid answer, but in my experience, you need to look at the evidence in its totality and see essentially what happened at that time, and not be influenced by what people will tell you after the event. Because as you can imagine, competitors also have an agenda, because if you prohibit a transaction, they may well be able to pocket an asset at a very low price, probably at zero.
Just one additional comment. There is one case at DigiComp. It's either, I believe it's either Calvin Salts or News Corp Teleview. I have it somewhere, the title, the case. And I can send it to anyone if the person who asked would contact me. But in that case, if I'm not mistaken, the DigiComp asked the parties or requested the parties to have an investment bank's report on the potential sale of the target as to other competitors. To what extent there could be other competitors that could be interested for the same target. I'm not sure if it's one or the other case. I have it somewhere in my documents, and I'm happy to find it exposed.
Thank you so much to Professor Kokoris and Mr. Sartakis for answering that. Does anyone have any other questions?
Yeah, I have one, please. I am Farah. I'm a case handler from the ECA. I wanted to ask if for the assessment of a failing firm, does it differ if the firm already exists in a declining industry? Thank you.
It's a very good question, right? if the industry is failing, the question is, I suspect, what the impact of that essentially decline is on whether it's disproportionate or not on the particular firm, right? So you can imagine a situation where the market size shrinks and everyone is suffering equally. That, at least in my view, and obviously Ioannis is the expert here, shouldn't make a difference in terms of whether you would accept a failing firm defense or not, given that the whole size, the market size, excuse me, is shrinking at the same level. If for one reason or another that decline, right, impacts more the alleged failing firm because for one reason or another, in terms of structure, capitalization, access to capital, particular business model, it is suffering more than its competitors. I think this needs to be taken into account both in terms of assessing the competitive constraints and also ultimately the failing firm defense. I can hear Ioannis nodding. I can see Ioannis nodding, which probably means that he agrees. Who knows?
Yeah.
Thank you so much
Yes.
for the response.
Oh
yeah, please.
Sorry.
No, please go ahead. Sorry for interrupting.
Yes, I agree, fully agree. And just if we draw a parallel with in the rationale with cases we have seen in declining sectors where firms have asked for either reduction in fines or for the creation of what was called the crisis cartel, the fact that the industry is declining has been incorporated in the authority's assessment of the claim. I'm drawing a parallel here, but just to add to Alex's point, which I agree with.
Thank you so much. Does anybody else have any questions from the participating states? Perhaps we could address how the treatment of failing divisions differs from the treatment of failing firms in different jurisdictions.
To my knowledge and in my experience, there isn't much of a difference in terms of the building blocks. Obviously, what is critical is to see to what extent the healthy parent, in a sense, right? So Nina Shell would be a good example of a case, is indeed has made that decision to exit this particular market. But fundamentally, I don't see a difference. There are cases like Aegean Olympic where essentially the failing firm was at the level of the firm, but also at the level of the parent company, given the Greek crisis was happening at that time, not being able to support the failing division with additional capital. So I think it's a combination, but I wouldn't draw a distinction between a failing firm and a failing division in terms of your analysis.
Thank you. That was very informative. So perhaps the Moroccan Competition Authority could comment on in what situations firms' exit from the market was the least anti-competitive option. And of course, if Professor Stratakis and Professor Kokoris, and Mr. Stratakis could also comment on that, that would be great.
Would you care to unmute, please, sir?
I do apologize. There was a delay in the voice. Could you please repeat the question? I couldn't hear it.
Of course, apologies. In what situations could a firm's exit from the market be the least anti-competitive option?
Be the least anti-competitive option?
Yes.
So exiting the market would be the least anti-competitive option. I'm not sure I understand the question.
I think, and correct me here if I'm not also fully understanding the question, but I think what you're asking is, when is the exit inevitable as an option, and is the best option to have from a competition authority point of view, because everything else would be more anti-competitive in a way. I think that's what you're asking.
Yes, correct.
Yeah.
Yes.
I mean, my only comment from a legal perspective is that the whole point around the failing firm defense is that essentially the exit doesn't, if it exits or if essentially it was acquired, it doesn't make much of a difference, because the thinking behind a failing firm defense is that if the firm exits, the other player will essentially acquire the assets and, more importantly, the business of that exit firm. Is that what you're alluding at? I don't know if, Ioannis, you have any thoughts on that.
Yes, correct. And also, I believe that Professor Kokoris' presentation mentioned whether the exit would be inevitable and whether that would not constitute significant anti-competitive constraints and would in fact be a more pro-competitive option. If correct me if I'm wrong. But.
Yes, and I can see an argument, right, that the firm exits and then its sales essentially are directed more towards the competitors of the purchaser, and therefore the exit would be more competitive than the acquisition. But that's essentially what the failing firm defense test would examine. And this is part of the third limb of the test.
Hypothetically, for example, the purchaser could be a new entrant, which would not enter, but for these assets, which would be ready to be sold as a package, and then allow the wanting to be entrant to actually enter. And in the alternative, they would go to one of the incumbents. As a hypothetical example here.
Yes, thank you. That was very informative. Could we perhaps discuss briefly of the failing firm or flailing firm defense were satisfied in that regard?
I think I've heard the word flailing. Am I correct? Sorry, I think.
Yes, I didn't hear the first. I also didn't hear the first part of the sentence of the question.
Yes, our apologies. We're having some technical difficulties. My question was if we could perhaps discuss the Amazon and Deliveroo merger and how the elements of the failing or flailing firm defense were satisfied.
Yeah, and I mean, that's a very good example of ultimately not being satisfied, because essentially, although at the middle of the investigation, or towards the end to be more precise, the CMA essentially cleared the transaction on the basis that, the business of Deliveroo was struggling because of the pandemic. Amazon's investment and the acquisition of, I think it was a minority stake, quite a small minority stake, was really important to avoid Deliveroo failing, and there was no one else willing to invest at the time. Ultimately, perhaps because of the comments and backlash that the CMA received, and more importantly, in my view at least, because Deliveroo's results, there was a reversal and Deliveroo essentially started doing quite well again. The CMA, in its final conclusion, did not clear the transaction on the basis of failing firm, but simply on the basis that, that investment, on balance at least, is not problematic, including the levels of control that Amazon will have over Deliveroo, mainly because they were not direct competitors. So I think Amazon Deliveroo is a better example of the impact of time and uncertainty than essentially a flailing firm in terms of how it was applied, but definitely it was taken into account during the process.
Thank you very much for that response. Would some of the participating states perhaps like to ask some questions to our experts? With their contributions, perhaps you can read off their questionnaires. Mr. Hisham, would you like to comment?
Yeah, if you don't mind that, I mean, the question you have asked is really important, but well, I was intending to ask the same question because for me it's a kind of dilemma. I mean, should we let a company fail and then go on bankruptcy and then because it's something like a zero-sum game. I mean, the company is deemed to disappear, so better to let it disappear according to the destruction creation theory, or should it be acquired by a company that can that is likely to strengthen its dominant position in the market? So that is the question: to what extent we can allow some big companies to acquire weak companies for failing companies, better than to let these failing companies vanish from the market because they are not competing or for other reasons. So this is a quite difficult question to answer, and I think it's a case-by-case solution. There is no one-size-fits-all in that field, I think.
Completely agree with the statement. I would add that I would advocate for a very clear separation between the failing firm defense and any other support measures that you would like to take as a state or as an authority. I'm thinking of state aid or any other kind of leniency, if you want, in the way you approach those cases. I would argue that merger control examines something which is very specific, which would be to what extent this transaction is anti-competitive, and only if this is anti-competitive, then I think you would examine a potential failing firm defense. And I mean, I tend to agree that because it's, as Ioannis said, is that get out of jail card, right? Especially when you have situations of merger to monopoly, and there have been quite a few examples to that effect, then that's where scrutiny is required. But I don't think that the failing firm defense can give good answers to the broader philosophical question or economic question as to whether allowing failing firms to collapse or not is good for the economy. I don't feel competent to answer that.
Thank you so much, Mr. Stratakis. Does anyone have any more questions or comments? All right, I think we'll now come to our concluding remarks. I'd like to thank all participants for joining us for this module, and especially Professor Koukouris and Mr. Stratakis and Mr. Hisham Bouayed for their valuable contributions. I will now yield the floor to our general moderator, Toa.
Thank you, Farah, and thank you, our respected speakers. We'll have a break for 10 minutes, starting from now, and then we'll return back at 3:55. Thank you.
Thank you very much.
Thank you very much.
you know. So.